Okay, welcome everyone. Today we have attorney Morris Sabbagh presenting about Medicaid and estate planning. He is a partner in Vishnick McGovern and Milicio's tax law, wills, trusts, and estates, estate planning, elder law, COVID-19 legal assistance practices. He focuses on assisting families with the preservation of wealth and administration of estates and trusts, and works with the high net worth individuals to prevent the dissipation of assets, taxes, creditors, and long-term care expenses. His extensive experience includes planning for gift, estate, and generation skipping transfer taxes, business succession, marital issues, creditor and asset protection, and public benefits and elder law issues. So if you'd like to begin.
Thank you, Jacqueline. Welcome, everyone. Thank you for being here today and joining us to talk about issues that come up in elder law. I am an estate, trust and estates and elder law practitioner, and I've been doing this for about 25 years. And what we do as elder law practitioners is that we facilitate the legal issues that are very common and come up within the estate planning arena, the health care arena, and the like, for people who are older and need assistance in that regard. So what we want to focus on is very much like what we want to focus on for anybody that we're doing estate planning for, but there are additional considerations and additional things that must be looked into and thought about as people age, such as dealing with the potential for elder fraud and elder abuse, making sure that the long-term care costs of the person who we're planning for has been considered and is going to be well handled and planned for, and also to consider what happens in the event that this elderly person is not able to make healthcare decisions for themselves at some point in time, or is not able to make financial decisions, handle their checkbook, pay bills, etc. And these are the things that we want to focus on and consider when we're meeting with families. Typically, when I meet with a family, I'm not just meeting with the elderly party. I'm very often meeting with the spouse, the children of the party who's looking to do the planning, and we are going to want to get a lot of information before we can really guide them in terms of what is needed in any person's particular circumstance. Okay, so let me just start by talking about the basic documents, and this really applies to just about anybody who's doing estate planning. There are certain documents that everyone should have in place, and sometimes when I meet with a family, they already have some of this in place, and sometimes they don't. But certainly if they do have them in place, these documents in place, I want to see what they have in place. I want to see if there's any major changes. And this is, I'll get into that in a minute in terms of, comparing the old documents to what we have now or what's being proposed. But just in general, the documents that we always want to see that everybody should have is a power of attorney, a healthcare proxy, sometimes a living will, and a will. Okay, and then we get into trusts, and people always want to know about trusts and why we use it and how we use it and all that, and we'll talk about that. But generally, basically, the things that everyone should have, even at a younger age, are these 3 or 4 documents. So the first one is the power of attorney. Power of attorney is a document that is used to give someone else power to sign for you or for your loved one, to deal with banking, to deal with real estate, to deal with any kind of assets, or income, or Social Security, and all these things that have to be dealt with. Because we all have to be mindful, even at a younger age, that there could come a time when even though I want to be able to handle everything for myself my entire life, but there could come a time when I'm not able to do that because of some type of incapacity. So because of that, we want to have that first document we want to make sure everybody has is a power of attorney. And the power of attorney, again, is putting somebody in place to make these kind of decisions, financial decisions, and to sign for you or for your loved one in the event that they can't do it for themselves. And there are 2 or 3 different types of power of attorney. One is a springing power of attorney, and that's power of attorney that can only be used if the party becomes incapacitated. And some people don't feel comfortable giving either their spouse or their children or a friend or whatever power immediately to sign for them or to go to the bank and withdraw money or to sign on a real estate transaction. But they will feel comfortable in the event they ever become incapacitated. So some people only want to do a springing power of attorney. Others will do what we call a durable power of attorney. And a durable power of attorney is a power of attorney that can be used today, tomorrow, the next day, even if the person who's giving power of attorney, becomes incapacitated. So in other words, by putting a durable power of attorney in place, I am immediately giving power to that person, whether it's my spouse or my child or somebody else, the power to sign for me. That doesn't mean I'm giving away my rights to sign for myself. It just means that I'm adding to the people who can sign for me. And sometimes I'll give it just to one person. Sometimes we can give it to several different people, or we can give it to them in a certain order of priority, first A, then B, then C. And the reason it's so important to have this, now the one type of power of attorney that you don't want to have is one that terminates in the event of incapacity. And so you want to make sure that it's done properly. The other thing is that, there are a lot of forms out there, powers of attorney, that people, they just go out and sign a form. Unfortunately, 90% of the time when somebody comes in with a form that was signed maybe when mom or dad was in better condition, was notarized and everything, there's always some type of a problem that I find with it in terms of our being able to do the planning that needs to be done for elderly people when they are no longer able to do it for themselves. One of those things is the ability to make gifts, the ability to set up trusts, and to make transfers, right? Because when it comes to Medicaid planning, which is something that we're going to talk about, it's very important that if the elder person is no longer able to do that for themselves, to make the transfers to themselves, that there should be someone out there, whether it be a spouse, whether it be a child, that can do it for them. Right? So in New York, until May, when the law is going to change, but for now, in order to give that power to make gifts and to make transfers, set up trust and the like, we need something called a statutory gifts rider attached and properly filled out with that power of attorney. Without that, if somebody comes in with a power of attorney that doesn't have that statutory gifts rider, or even if it's not a New York power of attorney and it doesn't have the proper gifting powers, a lot of things that we would have been able to do to assist them, we don't have the power to do. And that's why one of the first things that I want to put in place for people when they come through the door and they don't have it is to make sure they have a power of attorney. Because believe me, I have people who come in here and some of our clients can be very, keep things close to the vest, don't want to share information very much with their family members, want to do everything for themselves and not so willing to give up power or to give up information or to make transfers that might be necessary in order to get them certain government benefits. But if they at the very least do a power of attorney, and it comes to a point where they become incapacitated and they need certain government benefits that need to be planned for, at least that power of attorney is in place so that they can do the proper planning, or their family member can do the proper planning for them. So that's the first document that I really want to make sure that everybody has. Second document that I want to make sure that everybody has when they come through the door is a healthcare proxy. And what the healthcare proxy does is it puts in place someone, and hopefully more than one person in order, who can make healthcare decisions for the individual in the event that he or she cannot do that for himself or herself. And we all have to be mindful of this, even younger people. There have been several cases that went to the US Supreme Court where family members are fighting over the healthcare decisions to be made for somebody in their 20s. And two of the major cases, the Cruzan case and one other case where there was a big fight between the parents and the spouse over whether to withhold or withdraw life support because there were no directives in place. And these cases were with people who were in their 20s. So we all have to be mindful that due to an accident or disease or whatever, any one of us could at some point in time become incapacitated and not be able to make our own healthcare decisions. For this reason, we want to make sure, especially with the elderly, that there is a healthcare proxy in place to allow them or their family members or their significant others or best friend, whatever it is, to make those decisions for them if they're not able to, and to sign off and to access medical records. So, including in this is a HIPAA release. We want to make sure that they have access to medical records. So that's that's your healthcare proxy, and that's just basically appointing an agent to make decisions and access medical records for the individual if they're not able to do that. Then there's something called a living will, which is different. Now, the healthcare proxy deals with any kind of everyday decisions. It could be, admissions or discharges to hospitals, consents to surgeries, access to medical records, all those things. But when we're talking about end-of-life decisions, meaning to provide or not provide life support, or once a person is on life support, whether to keep them on or withdraw that, typically the healthcare proxy alone is not going to be enough, or might not be enough unless the agent specifically knows what the wishes and can express what the wishes of the elder person or the other person that they have healthcare aid, the healthcare agent for, would have wanted in a certain circumstance. So what a living will does is it talks about that issue. If I, as the person who's signing this document, ever am in a position where I'm not able to make a decision for myself, and there's a question as to whether I want to be kept on life support, do I want that? And there are religious situations that come into play, and some people want to have that put in, considered in these documents. But in any event, these are the documents that we look at because we want to make sure that if a person ever becomes incapacitated, number one, that there is somebody to make financial decisions and handle financial matters for them. And number two, that there is somebody who can make medical decisions and the like for them. Next, that I want to make sure everybody has is a will, right? Because the will is the document that says that in the event that I have assets at my death, this is how they should be distributed. Now, so when a client is coming in, whether whether they've done planning or not before, I want to know that, and it's very important because I want to look at what the prior documents say. I want to see, are there any major changes being made here? Was it everything going to, all the children, and all of a sudden now person is coming in saying, no, I just want to give it to one child? Or is there an outside party is getting it, and prior to this, there were other people? Because that might flag something that I need to consider in terms of elder, fraud, elder abuse. And, is there a major change to the prior documents? So we always want to look at the prior documents. And we also want to see what the assets are that are involved. Is there a home? What kind of other assets are there? Are the stock accounts? Are there stocks, certificates? Are there government bonds? We want to know about all this because in order to properly plan for any individual, we need to know what they have. I also want to know who their closest people, who's important in their lives, whether that be family, whether that be friends, or anyone else. You know, who is in your life and who do you want to provide for? So these are all the things that I want to gather, the information I want to gather in order to guide anybody in terms of their estate planning, but also in terms of planning for long-term care. So when we're talking about elder law, very often people think of planning for the costs of long-term care. What does that mean? So as people age, they start to think, and typically I find that it's late 60s, early 70s, people start to think about this, is if I ever need long-term care, how am I paying for that? And when we're talking about long-term care, we're talking about an ongoing continuous need for either a nursing home or other kinds of institutional care, or at-home care, either several hours a day, 12 hours a day, 24 hours a day for an ongoing basis. Right? We're not talking about a short-term rehabilitation situation. We're talking about that long-term need that sometimes arise as people get older. And I have clients who are over 100 and never need it. But then there are others who need it sooner, sometimes in their 60s, sometimes even earlier. And these are things that have to be planned for. Why? Because Medicare, which, you know, most people once they're, over a certain age are relying upon for the purpose of most of their medical care, Medicare is not covering long-term care. Okay, Medicare will cover certain rehab, whether it be in a rehabilitation facility or at home, for a limited period of time. But they're not covering for an ongoing need. And therefore, as we get older, we need to think about, how am I going to pay for that? If Medicare is not paying for it, how? So generally, what I tell people is that there are really three ways that long-term care gets paid for. Either you're paying for it out of pocket, or you have long-term care insurance, or the government is paying for it. And when we're talking about the government paying for it, it's in most cases, we're talking about Medicaid. In some cases, we're talking about some or all of it being paid from the VA if they qualify. Let's talk about self-pay to start, okay? So as far as private pay, it can be quite expensive, especially if we're talking about round-the-clock 24-hour care or institutional care in a nursing home. And most people, if they ever had to pay out of pocket, will run out of money eventually and eventually have to use government benefits. The typical client has who comes in to do elder type planning, Medicaid planning, they're going to have very often a house and maybe some invested in assets, a small amount of cash in the bank, but we're typically not talking about a huge amount of assets. So we're concerned that those assets are depleted. And if they're depleted, that means that they eventually go on to government benefits, but they have no backup. They have nothing to pay for those other things that might come up, right? So we're not always so concerned about, is the main issue to get assets to the children. Sometimes that's a very important thing to people, and that's why they're doing the planning. But we also have to consider that, if I spend every penny on my care, I'm not going to have that money to back me up to provide other types of things, other needs that might come up. Or I have to think about where I have two spouses and one spouse goes into a nursing home and the other one is home. and the assets start to get depleted to pay the nursing home bills, what is the other spouse left with? And what is the quality of the surviving the other spouse's life while that the spouse is in the nursing home and after that spouse's death? Should the community spouse, the spouse who's at home, should they survive the one who's in the nursing home? So we want to plan for these things, because we don't want to put the spouse at risk of having nothing because it all went to pay for long-term care. So that's the first. The first way is to pay out of pocket. The second way is to have long-term care insurance. The issue with long-term care insurance is that, number one, typically you need to take it at a younger age when you don't have any major health issues. So that prevents some people from getting it. It can be costly, although for some people, for the right person, it's a great option, because if they can afford it and if they have sufficient income to cover it, it avoids the issue of having to deplete assets to pay for the care or to make the person Medicaid eligible. So it's an option that should be considered and looked into for everybody, although not everybody is either going to qualify for the insurance or can afford it. And then the third option is Medicaid, and sometimes, like I said, VA. But with those programs, you're going to find that in order to qualify, you have to have limited assets. Okay, and I could talk about a little bit about what I mean by limited assets, but these are programs. Medicaid, especially, is a program that's really was created to help people who were impoverished. It's not created to help just every other person who needed care. So Medicaid is something that's designed for the impoverished, and therefore, in order to qualify, you really can have limited assets. So what does that mean? That means that for some people, the right thing to do is to plan by moving those assets, restructuring their assets so that they can qualify for Medicaid. And for everybody, that's different. So to think that you're going to go online and figure this out, I strongly advise against it. There are so many technicalities that you need to know when you're doing Medicaid planning, that you really need to work with elder counsel in order to do it right. There are all kinds of transfer rules and penalties that can apply, and things that you might not know about that might be available. So, for example, when doing Medicaid planning, somebody might not know that if there's a minor child involved, or that there is a child or a family member who's disabled, that there might be transfers that are exempt that will not cause them to lose Medicaid when they do Medicaid planning. So very important to involve the elder attorney in this. And they need to have all that information that I talked about up front. They need to know what the assets are. They need to know who the close relatives are. They need to know the history in order to guide you properly. So I just want to go into the rules on this a little bit in terms of Medicaid and what does it take to qualify. I'm going to work with New York. I don't know if we have people here from other states, or to what extent we're strictly dealing with New York, but I'll work off of New York just as an example. Let me see if I could pull up. Okay, no, I'm not able to pull it up. So let me just give you an example of some of the rules that apply in New York. And New York is pretty New York is pretty easy in terms of getting Medicaid qualification compared to some other states. And most states have limits are much stricter than New York are. But let's just talk for a second about the limits on what a person is allowed to have in order to be on Medicaid. So, for example, if somebody wants to go onto Medicaid, they're a certain single person, and they're applying for Medicaid and they need long-term care. And this is a person who's either disabled or who is elderly, who's over 65 in this case when we're talking about Medicaid. And what is Medicaid going to look at? They're going to look at what assets they have when we refer for Medicaid purposes of what the resources are and what income they have. And either of these can disqualify a person from getting Medicaid. So for example, in New York, a household of one person living alone applying for Medicaid can have $15,900 in assets. And when I say assets, those are non-exempt assets. If a person's living at home and they own their home, that house that they own can be an exempt resource, and Medicaid might not consider it. In fact, up to $906,000 in value of a home can be considered exempt, and a person could get onto Medicaid. Is that the right thing to do, and just to leave the house in the name of an individual and apply for Medicaid, even though they can qualify? No. The answer is typically no, because what happens is person goes on to Medicaid, they live at home, they're getting care at home, the house might be exempt, but eventually, after, if they eventually go into a nursing home or after death, their Medicaid can have a claim against the home for any care that was provided and the money that was spent. So you need to look at the assets that are out there. You also need to look at the income. So also looking at it from the perspective of a single individual, mom or dad living at home alone, and they have assets and income. We want to look at the income as well. And so for 2021, for a household of one, it's about $884 plus another $20 for the household. So it's about $900 in income that they can have a month. If they have more than that, then there's some planning that can be done. There's something called a pool trust. Somebody's living at home and they're disabled. Their excess income can be put into a pool trust and used to pay for things like real estate taxes, utilities, and the like. And that's one of the things that an elder law attorney can assist with in these situations, in terms of helping a person to deal with the fact that, yeah, I have too much income, but is there something that can be done anyway to make me qualified? Now, what if the person has too much in resources? They have a house and they have $40,000, $100,000, even $200,000 in assets. Can they qualify for Medicaid? If they hold on to those assets, no. The answer is no. However, there is planning that can be done. Number one, monies can be spent down, right? So money spent on proper expenses will not be, when Medicaid looks at a person's history, which they do, and sees how that money was spent on proper expenses, that will not penalize a person. However, when a person makes transfers, there can be a penalty for making those transfers, right? And this is where the term Medicaid planning comes in, right? Because when somebody comes into an elder law attorney and says, hey, I need to get onto Medicaid, but I have too much assets, what can I do? This is what we are here to help you with. We want to look at the assets and see, number one, are there any exemptions that I could take advantage of? I gave you the example of the minor child, that maybe there's a minor child or a disabled child that I might want to provide for. Transfers between spouses are exempt, right? So sometimes there's a benefit to shifting assets from one spouse to the other. Okay, you need somebody who's familiar with these rules to tell you these things. Now, so let's talk about the transfer rules. When a person, there are two kinds of Medicaid applications that are made when it comes to long-term care. It's either an institutional application, which means that the person is applying to go into a nursing home, or it's going to be a community Medicaid application where the person stays at home, continues to live at home, but is receiving long-term care benefits in the house. And that's community care. And the rules for these two types of Medicaid applications are different. Now, in terms of the institutional care, that's nursing home care, the rules have always been stricter, and they continue to be stricter, but the rules are ever changing and have to be monitored. So, for example, if a person has assets in their name and they want to qualify for Medicaid, but they're over the resource limit, there is the ability to transfer assets out of their name, okay? And when they transfer those assets, the Medicaid is going to look, when they put their Medicaid application in, Medicaid is going to look back. In the case of an institutional Medicaid application, meaning they're applying for nursing home care, Medicaid is going to look back 5 years. That's 60 months. What do I mean by look back? I mean that every statement, every bank statement and every brokerage statement, anything having to do with the transfer of real estate, all of these things must be submitted with an institutional Medicaid application for 60 months so that Medicaid can review and see whether there were large transfers made. Typically, when we talk in New York, we're talking about large transfers, we're talking about $2,000, $2,000 or larger. But sometimes they'll look at transfers that are smaller than that if they accumulate to a lot of money. Okay, so what happens then? What happens is that let's say somebody was to make a transfer. The Medicaid is then going to apply a penalty period for that transfer. Okay, so if a person applies for Medicaid within 5 years, and within 5 years prior to that application, there was a transfer, Medicaid is going to look at it, and they're going to apply a penalty of 1 month for every, let's say, $13,000 transfer. Okay, and it depends. So for example, in New York City, the number is $13,206. So for every $13,000 transferred, we're going to penalize you 1 month. And Long Island is $13,834. So different parts of the state are different, and from state to state it's different. And in some states it could be $6,000. And so for every $6,000 transfer, they're gonna penalize you. So that has to be taken into consideration. So doing institutional Medicaid, when we're doing planning, we're either doing long-term care planning, which means that person needs no care right now, but they are getting older and they recognize that there might be a time that they need to be on Medicaid. So what happens in that situation is we have the ability, there's a lot more that we can do for them. Why? Because, as I said, Medicaid's only looking back 5 years, right? So as long as today we do planning and we set up the proper trusts and we do the transfers properly, once that 5-year period is over, that person can qualify for Medicaid, even though they made sometimes very large transfers out of their name, and they can still qualify for Medicaid because on the application, they're going to show 60 months worth of statements. And if during that 60 months, there were no transfers, then they're not going to be penalized. So that's what we call long-term advanced Medicaid planning. But sometimes people don't do that. And they come to us and there's an immediate need to go into a nursing home. And there are things that we can do for that person. We're probably not going to be able to save them all of their assets, but we might be able to save them some of their assets and still allow them to go even into an institutional setting, even into a nursing home. Okay, so these are the things you need to be aware of. When we're talking about community Medicaid, until recently, New York State did not have a penalty for making transfers. In other words, when a person made transfers, they can within a month or two after making those transfers qualify for Medicaid, even though they made those transfers, even though they were over a certain amount, because Medicaid did not look back as they do for institutional care. That is changing. It was supposed to change as of October 1st of 2020. It didn't. They pushed off the date to April 1st because of COVID. It appears that they will push that date off again soon, meaning that they're probably, and this is just, whatever we're hearing verbally from the Department of Health, they're probably going to push it off until the COVID pandemic is under control and all the emergency situations are no longer applicable. So as of now, we are still in a state where an application for Medicaid can be put in for community care in New York without a look-back period, no look-back period. However, once the new rules come in, there will be a look-back period of 30 months. So 2.5 years, they will look back at any assets that were transferred and they will impose a penalty. How that's going to be calculated exactly, we don't know yet. We don't have guidance from the state yet. But eventually we will have better information on that. And so what does that mean? That means that for some people, where they're kind of borderline and, do they need care? They don't need care. This might be an ideal time before the new rules come into place that they should be thinking about, hey, do I apply sooner rather than later and do this planning sooner rather than later in order to make sure that I am going to qualify. Now, before I move on, I just want to see, are there any questions, anything that needs to be clarified, before I start to talk about trusts and the different types of planning that's done?
Yes, I have a question. When you're talking about the transfers, somewhere somebody told me that if you give $10,000 like to your grandchildren and to, I don't know, whatever, that will not count towards transfers. It's like gifting.
Oh yeah, that's a great question. I get that question all the time. So here's a story with that. In terms of gifting, historically, for tax purposes, there's always been this $10,000 limit where I can give up to $10,000 to as many people as I want in the world without having it count as a gift, a taxable gift, right? So it's a tax concept. It's now, that number is now up to $15,000, okay? Oh. So I can give $15,000 to as many people as I want, tax-free, without it being, as long as it's an outright gift, tax-free without being counted for gift tax purposes, okay? However, that is not applicable for Medicaid, right? So when we're talking about a Medicaid application and they look at and see those $15,000 transfers, they will penalize those. And in the case of an institutional case right now, at least, they will say for every $13,000 transferred or 11, or depending on what county you're in, they will penalize that. Okay, so even though for tax purposes it's not an issue, for Medicaid purposes it is. Now, most people doing elder plan, this type of Medicaid planning, are not going to be concerned about the tax part of this. And the reason is that in addition to that $15,000 that you can give to as many people as you want tax-free, as long as it's an outright gift, you can also, as far as the federal government is concerned, you can give up to $11,700,000 as long as you file a gift tax return and not have a gift tax. And the New York State exemption is $5,930,000. Okay, so for most people doing Medicaid type planning, they're not concerned about that issue. Okay, but you need to know that it doesn't apply for Medicaid purposes. Medicaid purposes, it's going to be considered.
I have a question.
Good question. Yeah.
What's under consideration for how they will penalize for transfers in home care?
So
Once
say that
the
again.
once the rule goes in that there's a look back period for transfers for community Medicaid, how will they assess a penalty? Because some people get 4 hours, some get 8, some get.
Okay, so that's a really good question. And you know what? We don't really know. We suspect that they're going to use the same or similar transfer penalties that they use for nursing home care, but we don't know. I mean, theoretically, they can come up with, they could say it's, half the amount, but it's unlikely that they're going to say, well, for this person, it's this, and for that person, it's that, because they have different level of need.
So are you saying that they'll look at a penalty of transfers of $13,000, you won't get 1 month of home care?
Yeah, again, it's something that they have not published yet. So we have no idea. And they really haven't given, they've given us guidance in terms of when they're going to start to implement it, but they haven't given us any guidance as how they're going to calculate it.
Thank you.
Okay.
I have another question. If, let's say my spouse needs to go to a nursing home, I was told that it was best to put the house in my name only. Would that help?
It sometimes will, right? So that is one way of dealing with. So if you're in a situation where you are where your husband is in an immediate need for care, right? So you don't have time to go through this whole process, right? Now, the house that goes in your name, as long as the spouse, we would call you the community spouse, as long as the community spouse is living in the home, that house is going to be exempt. Medicaid is not going to count it. Okay. So for somebody who's in immediate need, yes, that could be a proper approach to dealing with the situation, right? When you start to look at other assets besides the house and put it into spouse's name, that might also be a good approach, but sometimes you're going to need something, what we call spousal refusal. Spousal refusal is where you say, yes, I have more assets that I'm allowed to have as a spouse, but I need that money to support myself, and I'm not able to provide those assets to the support or to the payment of my spouse, and therefore Medicaid should kick in without it.
Mm-hmm.
What that means is that the government still has the ability to go after that community spouse for contribution, but they may or may not. It really depends on how much they're spending for the priority and how much assets they have to go out after, right? And it also depends county by county. Some counties take different positions in terms of who they're going to go after and who they're not, or if they're even going to pursue these cases. Okay, so that spousal refusal. But what you should know is, in terms of somebody who's in a nursing home, and in some cases, depending on what kind of care they're getting at home, the community spouse, is allowed to have a larger amount of assets, somewhere between $74,820 and $130,000 in assets, and still have the spouse who's in need of care qualify for Medicaid. There's also an additional amount of income that spouse can have. The non-nursing home or the non-needed, the spouse who does not need care can have up to $3,259.50 a month in income, and that could include some of the income that's taken from the spouse who's in need and given to the spouse who's not in need, if the spouse who's not in need doesn't have sufficient income. Okay, so that is something, and these are all the types of things that in everybody's situation is different. Everyone's situation is different. So to say that there's one right way to deal with these things for everybody just doesn't exist.
Now, does this New York law only apply if you're a resident of New York? Because I'm a resident of Florida, but I live in New York. half-time.
Well, here's the thing. When you apply, you're going to apply in the state where the care is going to be needed, right?
Okay,
So, yeah, so if your husband's applying, he's applying wherever he's going to be getting the services. So you have to take into consideration the rules of that state.
oh, all right,
Okay?
thank
I
you.
have a question. I wanted to find out, and I know this is gonna be like on an individual basis, but I find in order to do all this planning for the future and long-term and all that, it's expensive. And I'm saying it's like you work to pay to set all this up. It's like a contradicting effect. So about how much would it cost to get all of what you just said, the paperwork and everything in order to have it all set, approximately?
So, okay, so really it's going to depend on the situation. If you're talking about long-term advanced planning, you're probably looking, to have all your documents in place properly. It could be somewhere starting in the range of maybe, if you're doing a trust, let's say, and doing all your other documents and putting it in place, you could be talking about 4,000. You could be talking about more. Could be talking about 20,000, depending on what the assets are and what has to be changed and things,
Okay.
right? So it really depends on the situation.
So starting, think about the minimum of 4,000.
I would think so. If you're going to have all those documents in place, power of attorney and healthcare proxy, living will, you're going to have a trust possibly. You're probably going to be looking somewhere starting in that area.
Okay, thank you.
I have a quick question. Is assisted living considered institutional for Medicare?
No, it's not. But so and this is something that varies heavily from state to state. In New York, you have two types of assisted living facilities. You have assisted living facility, then you have assisted living programs. An assisted living program is one that is covered by Medicaid, but there are waiting lists for those. And it's possible to get Medicaid. That's still considered community care. So the rules are not going to be the same rules that apply for qualifying for institutional care. But there are facilities out there that do take the Medicaid. But like I said, waiting lists apply. Okay.
Thank you.
Okay. Any other questions?
I have another question. I was just wondering, I lived in New Jersey prior to coming to New York, and I had the proxy and the power of attorney done in New Jersey. Now, is that all going to be okay in New York?
You're best off having it, the documents that are familiar in the state where you live. Yeah, especially the durable power of attorney. Especially the power of attorney, they want to see the form that is for the state where you live. Yeah.
So should I have it looked at and
Absolutely, yes.
by a New York lawyer?
Yeah. Yeah. Now I'm just going to talk. I want to talk a little bit about trust, right? Because invariably people are going to ask me about a trust. I think somebody's trying to.
Can I ask a question?
Sure.
Yes. The question is, what about if there is a sale of a residence by the elderly, and he is now at a nursing home?
Mm-hmm.
With that sale of a residence, the elderly received net, let's say, 300,000,
Mm-hmm.
of which of that amount he gave to his children about 150 to 160,000.
Mm-hmm.
In regards to the Medicaid, which there would be an application,
Yeah.
would there be a penalty?
Okay, so that there would be a penalty. So this is what we call, emergency type Medicaid planning. Right? It's not long-term, it's an emergency situation. We want to do Medicaid planning. We got money in our name. What do we do with it? Okay, we used to call this, the technique, we used to call it the Rule of Habs. I don't know if people call it that anymore, but basically what we're doing here when we're talking about planning in that type of situation is trying to save some of that money, right? So for example, in the situation where I'm transferring some of that money to the child, to the children, it's going to cause a penalty. So what could I do? So there's this technique involves having a promissory note, either with the children or somebody else, where the money is given, the other half of the money, the half that's not being gifted, is given to somebody else as a loan. The loan is paid back on a monthly basis during the period of that penalty. So for example, let's say it causes a 15-month penalty. If the promissory note is being paid back over a 15-month period of time, the application for Medicaid goes in. Medicaid now looks at it and says, you made a transfer that caused a 15-month penalty. We're not paying for the next 15 months. The money coming in on the promissory note on a monthly basis is used to pay for the 15 months of care. And then after the 15 months are over, Medicaid starts, right? So what we've done there is you've protected half the money or something close to half, and you use the other half to pay for care. Okay, and that is a technique that we use. Again, it doesn't apply to everybody, but it's something that, everybody's not going to just know that, that they can do something like this.
Now, would it apply also the same way if the patient then is taken out of the nursing home for community Medicaid to live with let's say one child?
It may or may not. It depends on the type of program that they go into when they come home. Okay, and that's something that does complicate that kind of planning, because very often we have people come in here, the family comes in together, they're all looking for mom and dad's best interest. They want to do the right thing, but they're not sure. Is mom going to end up at home or in a nursing home? We want to bring her home. Is it going to be feasible? Can we keep her home, or we can just end up putting her back in the nursing home because it's not feasible? And that's always an issue, and it does complicate the planning process, because it makes it difficult to decide. And really, we need to know kind of which direction are we going? Are we going home care direction? Or are we going nursing home direction? Because especially now, planning community Medicaid is easier than planning for institutional care. Okay.
Thank you.
Okay. Okay. Anything else before I was going to talk a little bit more about trusts? Any other questions? Okay, so let me just talk a little bit about trusts. People come in all the time and they want to set up a trust. They don't always know why they want to set up a trust, right? There are so many different types of trusts out there, and trusts can be set up for many, many, many different reasons, okay? For Medicaid, typically when we're setting up a trust for Medicaid, what we're doing is it's usually long-term advanced planning where we're setting up, we're transferring assets, especially the house. So most often we're dealing with the house, and sometimes with other assets. And the goal is to protect the house so that when mom or dad goes on to Medicaid, the house is still protected. So upon their death, Medicaid does not have a right to pursue that house. Okay. Now, state to state, this is different. Okay. So I also practice in New Jersey. In New Jersey, we would not have the same type of trust that we have in New York. Okay. So the variations, you make sure that you're doing it. And sometimes I have clients who are plan to move in to another state. They have children who live in other states, so they might end up in another state. And that's something that you need to make the lawyer aware of, because if there's a possibility of moving to another state, they have to consider the laws of that other state when they're doing the planning. But in terms of the typical situation, we're trying to protect the house. We want to make sure mom or dad or both have the ability to continue living at home. But we don't want that house to be subject to recovery. Okay, so we could give it outright to the children. That's one way, but more often we're putting it in a trust. The reason we're putting it in trust are several. Number one, the trust is going to protect from the creditors of the children. Okay, whereas if I gave it outright to the children. Their creditors potentially can come after the assets. Number two, we don't want to have to worry about a child getting divorced and somebody making a claim against the assets and that are given. So if I give it outright to the child, potentially spouse can make a claim against it. If it's in the trust, then they're not going to be able to make a claim against that asset. Okay. Number three, tax, and this is a big one, right? When there are a couple of tax considerations that we need to think about. One is that if I own a house, and that's my primary residence, and I've owned it for 2 out of the prior 5 years, and let's say I own it with a spouse, right? I can sell that, make a gain of up to $500,000 on the sale and not pay any tax. But if I give that house to my children outright and they sell it, they're going to pay tax on all that money, including the $500,000 that I wouldn't have paid any tax on, right? If the trust is designed properly, which obviously that's why you go to a lawyer, is to make sure it's designed properly, then you're not going to pay, then you can avoid that gain, even if it's in the trust, Now, another issue is if I give an asset, let's say the house again, give it outright to my children, and my children hold it until my death, and then they sell it. Again, they're going to pay tax on the full gain. Whatever I paid, they'll deduct, but anything over that amount, they're going to pay tax on. If they inherited through my will or some other mean, like a trust, if the trust is drafted properly, they're going to get a new basis. They're going to give it, instead of deducting the amount that I paid for that house when they sell the house, they're going to deduct the value as of my time of death, right? So I paid $200,000 for the house. The house is worth now $800,000. The house is worth $1.2 million. They're going to sell for $1.2 million. And if that's the value that it was worth at the time of my death, because they're inheriting it, they didn't get it as a gift. If it was a gift, it would be different. Because they're inheriting it, they're not going to pay anything on that first $1.2 million in capital gain. Okay? So that's another thing that we want to do, is to preserve that, what we call the step up in basis for the family members, for whoever the recipient is. It doesn't necessarily have to be children, it could be anybody, that those people are going to be able to sell after my death and not pay capital gains tax. So that's another issue that has to be considered. And then there are other issues, including, who's going to pay the income tax on the money, and these are all things that get discussed when we set these trusts up. Okay, there are all kinds of other trusts that we do in estate planning that don't have to do with Medicaid, and those are things that for some people are the appropriate thing. Here's another thing that everybody, very often a family is dealing with the medical needs of the parent, and it's a really difficult time. It can be an extremely difficult time because mom or dad is just changed. All of a sudden, they become dependent. They need all kinds of care. You're figuring out, who has access to the money and who can make decisions for them, and talking to the doctors and talking to the social workers, and it can be very confusing. They're going to sit down with the social worker. The social worker is going to tell them all about these medical things, Medicaid and all kinds of things, right? And social worker doesn't necessarily know that person or their background. So they might not need to do any Medicaid planning. They might not have any assets. They might need to do some immediate care planning, or maybe they're not. Maybe they're worth several $1 million. The social worker doesn't know that. So a social worker might tell them, hey, you better go speak to an attorney about getting your mom on Medicaid. Or they get to the lawyer, and the lawyer says, well, your mom or dad has $10 million. You're not going to do Medicaid planning here. There's other kind of planning you need to do, right? So it's great that they have these resources and the social worker is there to help. But remember, whether it be the social worker or somebody that you speak to in the bank or a friend, just because it's what they did doesn't mean that it's what you should be doing in your circumstance. Everybody is different. And therefore, you need a trusted advisor who you can tell all the details to, and they can guide you in what's right for you. Okay. Any other questions? Anything that I didn't talk about that you would want me to talk about?
Well, what happens if you two kids inherit the house equally? Because I left, I mean, you know, everything like to the two girls, like I guess half and half. So how are they going to split the house? Somebody has to sell it?
Yeah, so, okay, so it's a really good question, because this is part of elder law, but it's also part of just estate planning. You know, it's an issue for everybody, and it's one of the biggest issues that I deal with, believe it or not, because, you know, we all hear about fights, and we hear fights over money and whatever, and sometimes the issue is, and I have one right now, I've had them many times in my practice, where everybody's getting everything equal, but they're fighting over what are they going to do with the house. They're getting equal, but they can't decide. Do we keep the house? Do we sell it? How much do we sell it for? I got two or three of these situations right now that I can think of. And so what I usually recommend people to do is to say, because I have to be mindful. One child is in need and needs the money, the other one doesn't, right? Who do I have to look after? I have to look after the one who really needs that money, right? So what I like to do, and when you know, a lot of my clients do, is we say in the document, whether it's a trust or a will, whatever, we say the house has to get sold as soon as practicable, unless all the parties agree not to, right? So what that does is it forces the issue. It says, no, we have to sell it. You don't want to sell it, you know, wealthier child, you don't want to sell it, then buy the rest out. But you're not going to prevent the ones who really are in need from getting the money that they need. And they're going to be dependent on it, right? So, and then they have to resolve it themselves, right? So you don't have one child, you know, forcing the issue or controlling the issue. That doesn't mean they can't agree to keep it. They can. But the document is saying it should be sold.
Is it possible to put your spouse's money or investments like a 403B or perhaps an IRA into the same trust that you have for your house in order to save money or taxes, or keep it from being looked at?
So I'm glad you brought that up, because I did not address it. But retirement accounts are assets that are difficult assets to deal with when you're doing Medicaid planning, because if you transfer them, you are going to accelerate the income tax on it, right? So we're not going to be able to transfer those assets unless, and it depends on the situation. Sometimes you got to run the calculation of what makes more sense. But typically, we're going to hold on to that. Now, in New York, not every state is like that, but New York will not consider those retirement assets if you're taking out your required distributions. They will treat the distributions that you're taking out as income. And they'll treat that as income that has to be either spent, or if you're at home, put into a pool trust to qualify. But they won't count that, the retirement account itself, as a resource that will disqualify you. But other states are different. Again, like I said, I practice in New Jersey. New Jersey will count that asset, okay? So, you know, now you have to think about how do I balance out the tax consequence of cashing in that account or part of that account with the fact that I'm going to be paying for my own expense rather than getting Medicaid.
So you need to continue to, whoever is in charge of the trust needs to consider the minimum required distributions.
Right. So you would not put the retirement accounts in the trust. but you would consider those required minimum distributions as income. And that's something that has to be dealt with in terms of what's going to happen with that income. Is some of it going to have to go to the nursing home? Because if somebody is in a nursing home and they don't have a spouse, then everything over $50 in income on a monthly basis is going to be going to the nursing home. But if they're at home, either that some of that money is going to get spent towards care, or some of that money is going to have to go into what I talked about earlier, that pooled trust. A pooled trust is not a trust that you create yourself with a lawyer. Lawyers are usually assisting with it, but you're usually creating, the only way to create it is through a charitable organization that has a pooled trust set up. And basically what it is, it's the charitable organization runs it, and they have a separate account for each of the people who are typical Medicaid recipients, and they keep track of how much money they have for them. And every month, the Medicaid recipient or somebody in the family is going to send them bills that have to get paid, and the pool trust pays it. So it's not the trust in your normal sense, that the type of trust that we think of on an everyday basis. It's a special kind of a trust. Yeah.
Thank you.
If you have your, I'm sorry, if your house is in your name alone, can you put your house in a trust? Is there such a thing?
Yes. Yeah. And that happens very often.
Could you say more about what it takes to put a house in trust?
So typically, what it takes is, number one, you're going to have a trust agreement document that's going to be prepared in accordance with your advice or with your directions. This is how I want things to be distributed. Trust agreement is prepared, and a deed is prepared. And those two documents are the two documents that you need in order to put the house in the trust.
So the deed now would say that your name plus the trust.
So the deed is going to change title to the trustee of the trust. Now, you don't want to be, when we're doing Medicaid planning, you don't want to be the trustee of the trust. Usually it's going to be somebody else who's the trustee of the trust. But you're still retaining the right to live there, right? So even though it's not yours anymore, you're retaining the right to live there. And typically we say there that the trustee needs your approval before they can sell, and that if the house is sold, it could be used to buy another house for you to live in. And all these things have to be considered when you're drafting the trust.
Okay.
Okay. Somebody else? I think you're on mute.
I have a question.
Yes, and the question is in regards to, you mentioned the pool trust where one would be able to submit for any excess resources for Medicaid. Now, for a special needs child and having a supplemental special needs trust, can that supplemental special needs trust be treated the same, or it has to be a pool trust to put the excess income?
No, you have a choice there. You could do it in a pool trust, or you could do a supplemental needs trust. If the child is under 65.
Yes, 20.
Yeah, if the child's younger, you can do it. Now, what you should know also is, for somebody who's at advanced age, they can, if they make it what we call a sole benefit trust, and it has to be drafted in a way so it's recognized as a sole benefit trust, anything transferred to that will not penalize the parent either. So parent sets up the supplemental needs trust that's set up as a sole benefit trust for the child. Child still gets Medicaid. The parent is not penalized for that transfer.
Okay, so then let's say that excess income would also be able to be placed there, and there would be no penalty with regards to Medicaid.
Oh, okay. You're talking about excess income? No, that's not the case. Not excess income. Not excess
okay, so then with that excess income,
you would have to do the pool trust.
The pool trust?
Yeah.
Okay. All right. Thank you.
Okay. Well.
So I have a question. The question 8, if somebody have a trust already and they have a pool trust over there. So when they're applying for Medicaid, they need to open another pool?
The person is already on Medicaid, you said?
No, you already have a trust.
Oh, they all have it. No, yeah. The pool trust is different from the trust that you have either for your house or your other assets. It only applies if we're talking about community Medicaid. It's not for institutional Medicaid.
Okay, and can husband and wife apply together for Medicaid?
Yes, it's possible to put a joint application in. The qualifications are a little bit different. So for example, in New York, husband and wife can have $23,400 in resources, and they could have about $1,300 a month in income. If they're both living at home and applying for Medicaid for long-term care.
As previously you told, the husband can transfer the money on spouse's name, because let's see, then after a year or 2 years, spouses has to go for Medicaid. That will create a problem then.
Well, yeah, so right. So you should consider at that point in time doing the long-term care planning for the spouse. So once the first spouse is on Medicaid, if we're talking about institutional care,
yes. I think community care. I'm thinking about community
care. No, so community care. So in that situation, you might want to take it out of both names because you want to get both spouses qualified. So in 5 years, they're both qualified, right? So if we're talking about community care and it's being done before the new imposition of the penalty, then you might want to just get it out of both spouses' names in that type of a situation.
That will be best.
Right. Yeah. Right.
So they're going to consider.
You eventually want both spouses to qualify. You know, another situation that we have to think about also is in these types of situations where when one spouse has the assets, the other one doesn't, and is on Medicaid, what do we do with the will of the spouse who is not on Medicaid? Because what happens? Sometimes the caregiver spouse dies first, and then what happens? We don't want a will that says everything goes to the spouse who's on Medicaid. So you need to look at that too.
Oh, I see that. Thank you.
Yeah.
I got it. And just another question, last one. And let us see somebody helping somebody, giving them money overseas during the COVID, just to let them survive. They're going to penalize that too?
They will. Like I said, they're typically looking at larger amounts, $2,000.
That much.
Yeah, $2,000 and more. But they're not going to make an exception for something like that.
Okay, so let's see, I'm confused here. You said they're going to penalize for 1 month. Let us see, I pay like $5,000 for the aid, homemade, and they're going to deduct like a 13,000 something from that monthly. Only
No.
Let
me ask you. You spent the money on the aid. That's permissible. There's no penalty for that.
Oh, no penalty for that.
When we're talking about transfers, we're talking about uncompensated transfers, meaning you got nothing in exchange.
Oh, I see that.
Yeah.
Okay. So I don't have to worry about hiring an aide.
No. You don't have to worry about that. We're talking about
I want to
transfer to a friend, you're transferring to a child.
No one needs it. I want to apply for the Medicaid. I can afford to give cash.
Say that? I didn't hear the first one.
For the aid, then I need a Medicaid. So when I'm going to apply for the Medicaid to be qualified, so they're going to penalize me for that or no? I don't understand this.
No, you're saying you paid for the aid for a certain period of time and then you're applying for Medicaid?
No, I haven't started now. Yeah.
Yeah, you started to pay, right. So at some point in time, even if you've been paying for a while, if you do the planning and then apply for Medicaid, then they're going to provide potentially for care going forward.
Okay.
From the time the application is approved, possibly even up to the application date, sometimes even further back, but they're paying for you going forward.
Okay, but no penalty.
No what?
No penalty.
Oh,
We don't
no,
penalize.
it's, yeah, no, as long as, you know, the qualification is there.
Thank you.
Yeah.
Thank
I'm
you. very
sorry. I didn't quite understand. If I'm paying an aid to look after my spouse, can I? How do I get to? How do I claim to Medicaid ultimately?
So, right, so if you're paying for the aid, anything you've been paying for the aid is fine. It's not going to cause a penalty, right? But now you have to look at it. You have to look at the assets now and see, can your spouse qualify based on the resources and income that you and he have, right? So you're going to look at the both spouses and see what the assets and resources. And based on that, you might be able to put a Medicaid application going forward for future care, or you might need to do some planning in order to qualify the spouse for Medicaid, and then put the application in after the planning is complete.
What do you mean by planning?
Planning meaning these types of trusts and transfers that will make the person eligible.
Thank you. Thanks.
Thank you.
Okay, any other questions?
Thank you very much for a very interesting talk.
Okay, my pleasure. Thank you all for coming and joining us. I enjoyed speaking with you, and please feel free to contact us if you have any questions or.
How do we
want-
contact you?
Yeah.
Thank you so much.
Are we providing the contact information?
Yes,
Okay,
please.
then will be provided to you.
Okay, in an email? They're going to be emailing it to us?
Roy or Jacqueline, do you know? Yeah? It'll be emailed.
I think in the email we sent out, the flyer with all the information about today's meeting, the contact info should be there.
It's wonderful.
Okay.
Thank you.
Okay.
All right,
Okay.
thank you.
It was a
Thank you
pleasure.
very
Thank you.
much.
Thanks.
Take care, everyone. Bye.
Bye-bye.
Thanks
Thanks
a
a
lot.
lot.
Bye.